This is Valerie Guillaume. Let me expose in this video the public fraud that's being carried out at the Superior Court of Justice in Brampton, the Divisional Court. And I'm going to use my case as the example. You will not believe what has happened in regards to the clerks or the registrars in that court and their actions in trying to carry about a miscarriage of justice in my case. They have definitely interfered with the administration of justice with regards to my case. Now, what's happening is that the local government, the Regional Municipality of Peel, has brought a motion before the Divisional Court wanting to lift a stay, an automatic stay that I got from the court. Now, they filed their materials. The court allowed them to file their materials. However, when it came to my turn to file my document, meaning to upload my motion materials in response to their materials, I was blocked. Now, it has happened before because the motion hearing was originally set for July 11th. The court staff misled me and only provided for me a bundle titled appeal hearing when there was no appeal hearing on July 11th. There was a motion hearing for the respondents' motion on July 11th. Now, at the hearing on July 11th, the matter had to be adjourned by the judge, a newly appointed judge, Dirk Steen, and I have an issue against him as well because I was also asking for an adjournment on July 11th for those reasons, meaning that there was no options available for me to upload my motion material. Believe it or not, my response motion to Peel's motion, which they originally served me on May 20th. We're now in July, almost end of July. The first time I went to the court to file my response motion in regards to their motion, because their motion was to ask the court for direction as far as the automatic stay, whether it applied or not, and then to ask for an order to lift it if it did not. So I responded. The court would not accept my motion materials at that time, saying that they did not file theirs. So even though Jennifer Bruce served me hers, she didn't file it with the court. So at the case conference on June 9th, this was brought up because she was trying to wheedle her way and have it heard at the case conference. Anyways, I mentioned this in another video, so I'm not going to go into details about it in this video. Justice Trimble had her set date through Calendar, and so the hearing was scheduled for July 11th. However, when I tried to upload my motion material, my reply motion, reply factum, reply motion record to her motion, again I ran into difficulties. I was not able. The upload button was not made available for me to upload it to the motion bundle. The only option that was available for me for July 11th hearing was an appeal hearing, which there was no appeal hearing set by the previous judge at the case conference. What he did set out in his endorsement was that for the appeal to be perfected by me by July 14th and for them to respond, I think, by August 2nd. So how come the court clerk put appeal hearing for July 11th? Anyways, it went before the judge and I asked for an adjournment because I couldn't upload my documents. And so he didn't want to upload it. And what should have been a quick adjournment, this newly appointed judge said and done some things at that hearing which should not be. He was saying to the other people in at the hearing, oh, anyone have a quick adjournment, while at the same time, I asked several times in the morning for an adjournment at that time, and he did not respond. What he did was put it over for two something in the afternoon. And he was making statements like apologizing to Jennifer Bruce on behalf of her client. Like, I know you want to evict her from the shelter, but you know, this and that and this and that. But let me be more specific. I know that you want to have this motion hearing because you really want to evict her from the shelter, but he's apologizing to her for the delay. Excuse me, if that's not a lack of procedural fairness, I don't know what is. Because first of all, it was the court's fault. Let me move forward to the hearing that he adjourned for July 29, which now, and I took an image off the screen because I was not able to again upload my documents. That option was not made available to me, and Jennifer Bruce also acknowledged that in her email to me. And the little hypocrite and snake that she is, says, I will do it for you. So I said, go ahead and do it. And I waited for her to do it because I'm like, okay, she's a lawyer, she's busy. Let's just wait for her to do it. She didn't do it. And I also said that I was going to try to do it also. All of this time, I'm also adding the court's email to her email and to Kevin Koch's email because he's the lawyer for the other respondents. And the court is not responding, like, please fix the problem. I'm not available to upload my motion materials. That is severely prejudiced me. Because these material has to be uploaded to Case Center way before the hearing date, and the hearing is tomorrow. So that the judge could see, the motion judge can see what I actually filed. And so I had to actually now go through Jennifer Bruce, who is the respondent's lawyer, to have my documents uploaded to Case Center. What about my rights under Section 15 of the Charter? Equal access to the law and benefit of the law. If she was able to upload her document, if the option was provided by the court clerk, the registrar, the staff, the upload button was provided to her to these people are so crooked. The upload button was provided to her for her to upload her document, but not to me. That means they wanted to influence the outcome of my case. This should not be. I will show you the screenshot of my of Case Center where the upload button is missing, and then I took the image and I sent it to Jennifer Bruce, and I sent it to the court, and I sent it to the other party. I'm like, this is what is showing. I cannot upload my documents. The court has never responded to those emails, never. Not that they're going to do anything to assist me, but this is all part of the conspiracy. This is all part of Jennifer Bruce's involvement in it as well. For some reason, she doesn't want my reply motion for the judge to see it. Because in the body of the reply motion itself, I also listed the case laws, the precedents set by the court regarding that the automatic stay is also valid in my case. She has not filed that with the court. She filed all of the other materials that I sent her, and she only did it today. This is corrupt. First of all, you have the Canadian government wanting to put me out on the street. Because what she's trying to convince the court of is that she's allowed to transfer people out of that. First of all, that's a violation of my rights, Section 6 of the Charter, mobility rights, to live in any region, in any province, in any territory in Canada, and to seek a livelihood in those areas. What the Region of Peel has also done in my case is to cut off all services to me. All services. So while I'm in the shelter, the services to me are cut. The subsidy which all the residents get has been discontinued. And it is crucial for me in order to get out of that shelter. Not only did they prevent me in regards to my income for 2025, which I don't even want to go into in this video, because all of the funding that I was supposed to get with the funds being made available since March for all my writing projects could not go ahead because of what I've been through with the region of Peel and by living in the shelter. At the same time, they're asking the court to not only put me out on the street, but also to disregard my appeal. Now, Justice Trimble, as I said earlier, set dates for the appeal. Dates for it to be perfected by, date for them to respond by. And yet, I even noticed today that they also have up for an appeal hearing today. But there was no appeal hearing set for July 29th. So they're trying to circumvent, they're trying to undermine the appeal process itself. So I want to know if the judge is going to grant her request, because the court has already acknowledged this is going to an appeal. The order of Stuart LB is going to go to an appeal because she lifted the mandatory order against the region of Peel, which ordered Peel put me back into the shelter, in their shelter system. But because I could not go to the hearing, I was on 5 days medical leave. I couldn't go to the hearing, so Stuart J. lifted that mandatory order against Peel, which ordered Peel to put me back into their shelter system by Justice Fowler-Bryn. So Stuart J. now made the order lifting that mandatory order, which is also now under appeal. So now I want to know if the court is now going to listen to Jennifer Bruce, ignore the fact that this matter is now under appeal. I also, as an alternative, in case the automatic stay did not apply to me, I also filed a motion for a stay and the factum and all of those things under Section 96 for equitable relief. But based on my case laws that I've presented in my reply factum, in my reply motion, the certificate of stay should not be listed. Also, this woman is walking into the court and said, do this, lift it. And it's not done like that. There is a 3-part test to lifting an automatic stay set by the Court of Appeal. So I want to know if the court also is going to keep that standard that's been set by the court. No region of Peel, you cannot walk in here and say, lift the stay and make this woman homeless and living on the street. And you don't even have to pass the 3-part test to lift an automatic stay set by other precedents with the Court of Appeal for Ontario. And the first test of that, the first part of that test is the financial test, which, as the local government of Canada, the regional municipality of Peel, they're not short of money. So right away they failed that part. Jennifer Bruce has done so many things to prevent my motion material from going before the court, even now. What happened on July 11th, where I was, diverted from the motion hearing to some appeal hearing, which the judge acknowledged there is no appeal hearing today. There's a motion hearing. And that was the only option available for me to upload my motion materials. It was adjourned to July 29th, which is tomorrow at 10 a.m. Running into the same problem where the upload button was not made available for me, but it was made available to Jennifer Bruce, motion material. That is not fair to me or to anyone. So because I'm self-rep, they're trying to take advantage of the situation and take advantage of my rights. But the court is obligated to consider all of the circumstances. And the fact that the court has not responded, the clerks in the court has not responded, and says, well, you know what, the upload button wasn't provided because there were some technical issues or whatever. How could they explain it? Because the same thing happened for the hearing on July 11th. No upload button was provided for my motion material, and that's been acknowledged by the judge, Dirk Stein, who claimed there must have been some error on the part of the court clerk. Well, what's the excuse this time? Her motion should not go ahead on the 29th because my motion materials were not able to be uploaded to Caseline last week in time for the motion judge to review my documents. And some of the documents that I sent to the court for case center was my perfected appeal and the exhibit book and the factum on the appeal. And she conveniently did not upload that for me, saying that it was not relevant to her motion. Just like she conveniently did not upload my response motion. She did the motion record, she did the factum, she did the stay motion. At the same time, she's telling me your stay motion and the factum is not relevant to my motion tomorrow. We'll see. We'll see. So this is to expose what's happening in the divisional court in the region of Peel, the municipality of Peel, Brampton court location, where the staff has personally been intervening in my legal matter before the court and continue to do so. And their most audacious, nefarious, egregious action so far is to block me from uploading my motion materials for the motion hearing on July 29th, which is tomorrow morning at 10 a.m. I'm going to bring this up before the judge, show him the image that I could not upload my motion document last week when it mattered, and that it was the court's fault. I could not upload it. So this is what I'm exposing in this video today. Exposing Brampton Divisional Court. What they're doing in regards to me as a self-rep person, as a black person, and persecuted me. Every single one of them is going to be charged in the criminal court. I'm not even joking about that. Every single one of them who violate my rights, carry out this is cruel and degrading treatment. They're literally trying to force me out on the street, not to another shelter, on the street. Because what happened with other regions is that they're so booked up and so filled in other regions, they do not take people from other regions because there are people waiting in those regions for those places. So I will let you know what happened tomorrow at the court. And she should not be able to proceed with her matter tomorrow because it was unfair for me not to be able to upload my motion materials last week so that it could be reviewed by the judge for the hearing on July 29th. This is no oversight, especially since it happened the first time for the hearing on July 11th. So this was no oversight. This is the court now, the clerks in the court working with the other side, the other party, to interfere with the administration of justice in my case. In my case. So this is Valerie Guillaume reporting for Canada Human Rights Abuse, which is carrying out in my case right under the United Nations, right in front of the whole world, and basically mocking my situation, mocking the treaties, mocking those international laws, the treaties that it has signed, that it will not force anyone to be homeless. And these are all based on the corruption that's with the Regional Municipality of Peel. There's no justification. It's an obstruction of justice that they even wanted me to leave the shelter, because they want to interfere with they wanted to prevent me from getting that apartment. And even with that apartment, because I stayed both orders, the order lifting the interlocutory injunction, preventing the landlord from renting out the place, I stayed that order. And I have reason to believe now that they went against that order and rented the place, although I don't have definitive proof of that. That's a contempt of court, because there's a certificate of stay and that order has been stayed. So if they rented out the place while the order has been stayed, it's a contempt of court. It's a contempt of the order of the court. So this is Valerie Guillaume making this video exposing Canada human rights abuse and the atrocities that it is committing in regards to me, and trying to cause me irreparable harm, endangering my safety, endangering my life, and that this is being carried out by its local government, the Regional Municipality of Peel.